Hello again and welcome to Think Like an Attorney, the podcast. I am your host, Brendan Cody, with my co-host, Abraham Lincoln. He doesn't always have a lot to say, but I think he's already said everything we need to know through history with our great 16th president. The point I want to get across today and the topic that we're going to deal with is how to be a great client in your legal case. Most of our episodes are geared for paralegals, young lawyers, legal secretaries, and so forth. But this particular episode is going to be geared for the client. How can you best be a great client in order to maximize the results on your particular case? The point I want to get across here is that in this particular podcast, we have a guiding type of principle. And one of the principles is you either think or you sink regarding this particular podcast. We want to teach you to think like an attorney. There's no better person to think like an attorney is the client. The client learns so much from a lawyer. And in my book, I discuss that in Think Like an Attorney, Power Thinking for the Courtroom of Life. In this particular book, which is available on Amazon, I focus on the fact that people change and get better as a result of the legal experience, whether they're a juror or whether they're a client. We're going to focus today on the clients and when they retain a lawyer, what they can expect. What is the client's rights and obligations? The first thing I like to get across here is that clients must be aware, and it's a comfort, that their lawyer is their advocate. I repeat, the advocate for the client only. The lawyer is not representing society at large. He is not certainly representing the other side, the other client, the defendant or plaintiff on the other end of the lawsuit. He is not in cahoots with the insurance company. Your lawyer has an ethical obligation, ethical duty to work only for you. That's the most important thing we want to keep in mind when it comes to law and advocacy as well as ethics. The other point that a client should be aware of is that certain things lawyers really don't want to hear from the client. When you come to a lawyer, you want certain things to occur regarding your case. You want your case evaluated. Can I win in court? How strong is the case in effect? And one thing the lawyer does not want to hear is that I'm only seeking justice. Another way of putting it is I want to try the case and go before the jury on principle. Lawyers don't want to hear that. It's a tough world out there, but we have to keep in mind that courts, generally speaking, either deprive someone of their freedom or allow someone their freedom, or in the criminal arena, or there is a claim in civil court for money damages. Most court cases aren't going to force an individual on the other side to do something. We substitute that with money damages. A jury will have to decide what your case is worth. Or if you're not bringing a claim, if you're being sued, what will your insurance company or what will you have to pay as a result of a legal dispute? I want to keep in mind that money is not a dirty word. Monetary compensation is not a dirty word. Money is right up there with oxygen. Try living without it. It is the best measure we have on the value of a case and a result. Another point regarding our case with a lawyer is that many people expect us to have an apology if we have been wronged in our case. They expect the defendant to issue an apology. Some people say this is all I want is an apology, and that just simply does not fly. Again, we look to money damages in these particular cases, and in fact, what we have to look at is that in these cases, it's all about the Benjamins, as they say. I can't emphasize that enough. And every case has strengths and weaknesses, and many cases simply, and which we'll get to a little bit later, are going to have to be mediated or settled out of court. Remember to keep in mind 90% of cases settle out of court because of the risks and the dangers of going to trial. Another tip for clients that I'd like to get across to them is that you will be receiving mail, email, as well as snail mail, as well as texts from your lawyers. Please do not ignore them. Many times people feel, I just can't take another letter from my lawyer. They make me nervous. I'll ignore it for a while. The lawyer will send you letters and emails in order to communicate with you and, most importantly, notify you of upcoming events regarding your case. Those upcoming events can be depositions. They can be discovery responses that we will go over in a minute with your lawyer in his office. And will also require that, there may be settlement offers regarding the case. So sometimes people are stressed out, the client in particular, about their case. Don't ignore mail. It's important to look at that mail and to look at it in a timely fashion, not to wait on it. Another point that clients really don't know about is that the filing of your case is the beginning of all things in law and in the legal case itself. Many of the things that we do with our lawyer are in preparation and preparatory and come before the actual filing of the case. When things are in place, when the documents are gathered, when medical examinations are done, when reports are given by our doctors, once those things are done, the case would be ready to file with the court. It's the beginning of all things with your case, and it also starts a clock running. When we talk about filing, once it's filed with the court, your complaint or your claim petition or whatever it may be, or your petition, you will have it filed with the court, and that starts the clock running. It's in the court system. And many times you will not have a court date for maybe up to a year or more because the court system is backed up. I think what you need to kind of keep in mind here is that when it comes to your case, you are in line behind a number of people. Many people have obviously filed their case first, so you have to be willing to be patient and to wait for your particular case to come up for a final trial date. But many things are done in between that time of filing and the actual trial date. There is discovery responses, which you will issue in writing from your lawyer to the other lawyer. These are questions and answers and interrogatories that need to be completed, as well as your own deposition, where you will give your testimony under oath. Many people feel that, I want justice, and many times clients will quote, justice delayed is justice denied. This is a famous quote, justice delayed is justice denied, and it was issued by an individual by the name of William Gladstone, a former prime minister with Great Britain in the 19th century. He was a great prime minister, great statesman, but I'm not sure that he would have understood the importance and difficulties of trying a case and representing an actual client who's backed up in the court system. The point I'm trying to get across here is that justice delayed, justice denied is the rule. It is not the exception. It is a way of life in the court system. If you're unhappy with that delay, you can complain to the court. Don't blame your lawyer, because the lawyer, once he files the case, that is now on the court's timeline. And if things are backed up with judges, with court administration, you can complain to the government regarding that. It's not your lawyer's fault. The idea, again, is to be patient. Don't get upset. Things will occur before you know it, and things, once you get a momentum built and you get closer to trial date, many more things will happen, including the settlement negotiations. Another point, in order to be a solid, good client for your lawyer and to avoid unnecessary friction, is to be completely forthright and upfront and volunteer to your lawyer bad information. This means that if you've got a prior case in the court system, if you've brought a personal injury claim before, you must let your lawyer know that ahead of time. It's important to let your lawyer know about these things before he may have to find out from opposing counsel. And that's never a good thing for the lawyer to be surprised. There's an old quote from the Godfather book by Mario Puzo, as well as the movie, and it goes something like, Mr. Corleone, that's the Godfather, Mr. Corleone insists on hearing bad news immediately. And I think that's really important. Bad news is bad news, but it can become much worse if you hold back, if you conceal it, if you don't tell your lawyer right away. Bad things happen. Problems happen, but if you let your lawyer know in a timely fashion, and you can tell them this in all confidence, because there is the duty of confidentiality for the lawyer, you tell that to your lawyer in all confidence, he may be able to take steps in a timely fashion to minimize or moderate the bad news in your case. So don't be afraid to tell your lawyer bad news immediately. He will thank you for it, and it will reduce any friction you have with your lawyer. And another point regarding this is that you'll be required to give a deposition typically in your case, where you're giving sworn testimony under oath for several hours with a court reporter who will take everything down. The point I want to make clear is that when you give a deposition, you're putting yourself out there. If you can become and be A, totally prepared, and B, be likable, that is going to help your case get settled in the end. Or the other side will be very nervous about confronting you in an actual trial. So being a strong witness requires preparation, knowing all of your documents, knowing your timelines, knowing your history about yourself and about your case. Your lawyer will help you in regard to that in the deposition preparation. The next point that I want to be clear on is that if you're respectful to your lawyer, he'll be respectful toward you. Lawyers are human, and remember, if you feel you're unhappy with your lawyer, just get it out and talk with your lawyer face-to-face and discuss things and indicate your problems. I think that when you have problems and concerns, I think that's fine, but I would try to ration phone calls. I would try to ration your contacts with your lawyer to maybe once every 60 days. And every time you speak with your lawyer, make sure you have a list, a checklist, so you don't forget requiring more phone calls. So you don't forget what you've told your lawyer, what you want to talk to your lawyer about, and the discussion topics and talking points. I think if you have those written down and ready to go, it'll make things much more efficient with every concern you have with your lawyer. Another point that I want to be aware of is that when we talk about working with a lawyer, sometimes there may be real problems with your lawyer. Sometimes you just feel you're not getting along well. You have to remember it's a business relationship. It's not about feeling. It's about working a math problem, as it were. It's like a math problem. Take the emotion out of it and try to think maybe as your opponent might think in regard to your case. But despite all those things, sometimes we feel that I can't work with this lawyer. Be very, very careful about terminating your lawyer, because a number of things will happen if you terminate the attorney-client relationship. A, you can always do that. You can terminate the relationship at any time. You have that as a right of a client. But the problem is that you'll have to go to the next lawyer, and the next lawyer may be aware of your prior case. Sometimes many lawyers don't want to take a case that's already been worked on for a year or two, and they don't want to be dealing with someone else's work and then having to play catch-up for a trial date. They may decline your case. Also, when you if you terminate your lawyer, you have to be aware that when you've got a prior case and you're going to a second lawyer or sometimes even a third lawyer, you may be involved in a situation where you're an orphan, where many lawyers don't want to simply take that case. One reason may be that they don't want to take the case is that they'll have to share the fee with the first lawyer. The first lawyer will have a lien for hours put in if you terminate that lawyer. And so that may make the case unattractive from a financial standpoint if you're the second lawyer or third lawyer on the case. The other things that we have to keep in mind here is that your case may come up for a mediation, and most cases do before trial. This is usually a court-mandated type of process where there's a mediator, a neutral lawyer that has no axe to grind, has no skin in the game, and he is provided information from both lawyers, and he acts as kind of a super negotiator to try to get the parties to resolve their issues and their problems. What we want to keep in mind here is that the mediator is totally neutral. He's not working for either side, and a mediator will typically tell you about the bad things, the weaknesses regarding your case. The point I want to get across here is that with the mediator, he'll tell you things that you need to know that maybe your lawyer is a little bit worried about telling you, and a neutral person is best in that position to give a fresh set of eyes, a second set of eyes, a second neutral look at your case to indicate to you the problems and worries and concerns and risks that you may take if you actually go to trial. So I think that the mediator is always a very good person to kind of consider regarding their opinion. That brings me to my next point. There are certain opinions you do not want to talk to or to give a lot of credence to. That's your uncle, your cousin, your relative that you may talk to over the weekend, and they feel that you should get X amount in your case. They may feel that you're not getting your just due, that your lawyer is not doing the right job. My point here is that it does you no good to shop your case around to someone else. That's kind of employment of garage logic, and you don't want garage logic stepping over the good points and frankly bad points of your case. It's important you not speak to other people about your case. If you do, that person could be called as a witness at your trial, and everything you told that person is fair game. There's no confidentiality with Uncle Bob regarding discussions you have with him over the barbecue on a weekend. So I would stay away from talking to anyone regarding your case. Other things to consider is the lawyer has many, many file cabinets in his office. You are not the only client that the lawyer has. That is a fact of life. A lawyer would not be successful unless he has maybe a couple hundred cases with many, many clients. If he's only got one or two clients, I think I'd be worried about that. So just be aware he has other clients, he has other people that he has to deal with, and that it is going to account for sometimes delays in getting back to you regarding your case. But they will get back with you. Also, it's important, I think, to maybe speak with the lawyer's staff. I think they are the gatekeepers in your case. They are legal secretaries, they are paralegals, they are law clerks. They do a great job. It never hurts to establish a good relationship with them as well, because they can really help you in terms of dealing with your case and the day-to-day problems instead of directly talking to the lawyer. A couple more points I'd like to get across regarding a case. Prior court contacts. What does that mean? It's important you let your lawyer know right away, and this may be kind of in the arena of bad news. Let your lawyer know right away if you've ever been in contact with the legal system. This could be a divorce. This could be a criminal matter. You could have sued someone else in a civil claim for injuries, or you've been sued yourself. These are the number of ways that you can be in contact with the court system, and the court system is going to have a file on you. Keep that in mind, that in regard to court cases, there are going to be document after document regarding you if you're involved in a court case. You need to let your lawyer know that. The other side's going to find out anyway. They have a right to ask about that, because that is called a term called possibly litigiousness, that you're a litigant in multiple cases. That may be fair game to use against you regarding your case. So it's important to let your lawyer know about that up front as soon as possible. The last thing that I want to cover is that lawyers are specialists. They are not generalists. What does this mean? Back in the early 1900s or before, lawyers in small towns would be the jack of all trades regarding law. They would handle multiple cases in multiple disciplines. In this day and age, we can't do that. Lawyers specialize in one or two areas. You must be aware of that. Many times you may have an issue that comes up where you're bringing a personal injury case with your lawyer, but you also want to adopt a young boy or girl that through a prior relationship or whatever you want to adopt and get involved in the family law system. The lawyer may tell you, no, I cannot do that. A lawyer may tell you, I can't draft your will. I'm not a specialist. And many times lawyers will have to refer you to another attorney who specializes in that area. Don't be offended. Be aware that lawyers have malpractice policies. And those malpractice policies tell us that you're covered for only certain areas of law. If you stray from that area, you could be sued for malpractice if you make a mistake. So it's best that you have a lawyer that specializes in your particular area of law, and that may require multiple lawyers, and your lawyer will probably be very glad to refer you to a criminal expert or to a wills and estates expert or a family law expert for your other problems. So just kind of keep that in mind, that lawyers cannot be jack of all trades as they used to be. I think that pretty much covers it. If you like this episode, please hit like. If you can hit subscribe, that'd be great, and notify. That always helps us with our podcasts and the message that we're trying to get out. Thanks again for listening. Thanks for taking the time. And remember, think like an attorney. There's no substitute. See you next time.